presentation today is derived from research culminating in a recently published book, which has examined a significant 1993 U.S. Supreme Court decision. It involves two sources of tensions in U.S. legal history. Implicit in the presentation is a struggle between two goods, two purposes which are plausibly good. This is the conflict between church-state separation or government neutrality in regard to religion and religions and the rights of people with disabilities. That's to remain implicit. Explicit, however, is that the decision involved a situation well known to American jurisprudence. It pitted claims made under statute law, in other words, a law passed by a legislative body of a governmental entity, against the abiding guarantees embedded in and elaborated over time by courts of law in the United States Constitution and its amendments. That was the substantive work of Zobrest versus Catalina Foothills School District, which was based on a lawsuit filed by a middle-class couple, Larry and Sandra, or Sandy Zobrist, in behalf of their deaf adolescent son in the federal courts in Tucson, Arizona in 1988. Yes, it took 5 years for the matter to be resolved. A narrow majority of 5-4 ruled in the Zobrist favor. Up to that time, they had consistently received judgments against them from governmental law officials and 2 federal courts. Their victory in the Supreme Court was the only positive formal response to their legal claims to that point in time. We're going to interrogate the inner workings of the Supreme Court to understand the Zobrist victory. Now, most of you are aware that the U.S. Supreme Court is a court of final jurisdiction that hears on appeal lawsuits that may test laws for their constitutional standing. The task of the Supreme Court is to judge constitutionality and to stabilize law at its highest levels to make certain, to the extent that it is ever possible to do so, that the meanings of the basic document of American law are consistent over time. Every Supreme Court decision is built to one extent or another on precedents, hopefully working toward consistency derived from lawsuits heard in the past. And the building of these precedents over time constitutes American jurisprudence at its highest level of determination. Cases before the court have already been heard and judged at typically 2 levels before reaching the Supreme Court, to which they are appealed by litigants who have lost on appeal in a lesser jurisdiction, whether that's a federal or national jurisdiction or a state jurisdiction. The 9 judges of the Supreme Court, if you will, judge appeals of appeals. In line with its mission to stabilize the law, the Supreme Court typically agrees to hear only 3 to 5% of the appeals brought before it. These are lawsuits that typically involve sharply and plausibly contrasting principles of law and claims made under law, and hence establish the need for greater clarity. A vote of 4 judges determines whether the court will review a case on appeal. Now, even within this selective, complex appeal process, the court still tries to avoid judgments that explicitly test the actual words of the Constitution and chooses to rule around those words, or specifically with reference to statute law. The analysis of the lawsuit in question that we have done was developed along 2 lines. The first involves the backstory of the lawsuit, follows questions examined by legal anthropologists, such as why do ordinary individuals, as distinct from corporations, institutions, and other formal organizations, file lawsuits? How do people with little legal experience in the formal processes of the law imagine those processes when they initiate lawsuits? And what outcomes do people envision possible and likely when they confront the formal processes of the law? And the institutions, the courts and individuals, lawyers and judges, who they must engage with in pursuing legal remedies. While I will present part of this dimension of our work very briefly, that is the backstory or social history of Zobrist versus Catalina Foothills School District, the balance of the presentation will be presented by Bruce with a PowerPoint. and it concerns the Supreme Court's decision in the Zobris lawsuit as a case study in the way the court prioritizes and balances off legal claims based in different bodies of law against one another in its efforts to create doctrine and stabilize the law. In this case, the court majority chose to prioritize constitutional law over statute law at a time in which the court majority wished to shift the boundaries of interpretation in an especially conflicted area of interpretation. That is, the guarantees embedded in the two religion clauses in the First Amendment to the Constitution, those clauses promising religious liberty and government neutrality in matters of religion and faith. The latter is referred to as the Establishment Clause. There has never been a single definition of the term establishment. The amendment did not define the word, and it was not until a decision in 1947 that one Supreme Court majority opinion sought to render a precise definition. Nonetheless, it failed to end the struggle over its meaning, which of course continues to this day and will continue into the indefinite future. This is what concerns us today, the Establishment Clause in our presentation. The mid-20th century saw court decisions which created narrow and restrictive boundaries, often in lawsuits involving efforts to share public tax-funded resources for education across the lines of public schools and religiously affiliated schools, almost always Roman Catholic schools. The largest alternative school system in the United States to public schools has historically been based in the Roman Catholic Church. The application of strict tests of constitutionality in such matters often ended with judgments that were arguably self-contradictory, petty, and seemed, however consistent with regard to current jurisprudential doctrine, contrary to public welfare, and especially to the welfare of children as students. The Zobris lawsuit came at a time when there was a broad recognition among legal analysts, attorneys, and judges that there was a need to shift the boundaries away from this strict separation toward a greater accommodation of religion and religions, especially in the distribution of public resources in education. Now, what are the circumstances of the Zobris lawsuit? The oldest son, Jim, this handsome fellow whose image you see before you, was born in 1974 with an almost total hearing loss that was not diagnosed until he was about a year old. The Zobrist mobilized themselves with impressive single-mindedness after that diagnosis to the goals of overcoming Jim's disability through training and formal education. Furthermore, they educated themselves about their rights under law, sought counsel, and helped to organize the legal effort made in their behalf. As has been the case with many families with disabled children, the burden of gathering information, making decisions based on information, fell to Sandy Zobrist, the mother, who also was to play a strong role in the legal effort. The historical moment in which the Zobrists encountered the necessity of dealing with their son's deafness was one that seemed filled with possibilities for achieving the goal they set early in Jim's life, that he would live not in the culture of deaf America, sharing its language, American Sign Language, history, and identity, but in the hearing world, a goal which he as he grew older, Jim himself thoughtfully embraced. This has been called mainstreaming, and a federal law, the Education of All Handicapped Children Act of 1975, recently passed, inspired the Zobrist hopes and made them plausible. It was indeed intended to replace a long-standing situation in which almost all children with disabilities got no education at all or a vastly inferior segregated education. Later, the law was retitled the Individuals with Disabilities Education Act. This law was an expression of the movement of civil rights consciousness, activism, and protest from their location in race and gender in the 1960s and 70s to disability, as well as evidence of emerging medical and rehabilitation understandings of the possibility for overcoming disabilities. The assumptions behind mainstreaming were and have remained guided almost exclusively by what are called ableist understandings of the normative body and mind. Now, the 1975 law promised every disabled child the right to a free and appropriate public education, integrated as much as possible into the regular classroom with non-disabled classmates, on the basis of the negotiation between parents and public school officials of an individual education plan that created a plan for the child's education that dealt with the child's individual circumstances and needs. The monies necessary to ensure this were funds brought together by the federal government and individual state governments. In Jim's case, as with many other severely hearing impaired children, his needs were both multiple and expensive. They included both compensatory pedagogies and technologies. In other words, and minimally, speech therapy, and most important, a sign language interpreter to accompany him to class throughout the school day. As long as Jim Zobrest was enrolled in public schools, there was never any question that he was entitled as a right to the resources for his mainstream education aside his non-disabled classmates. His circumstances would change at the time he was scheduled to enter high school. There was at the time no public high school in the school district where the Zobrist resided, and the parents had to choose a high school for him to attend. For a variety of reasons, they rejected a nearby public school for him to attend and looked instead to enroll at Tucson's Roman Catholic High School. At this point in their thinking, their embrace of Saw Point Catholic High School involved, among other benefits they sought from Catholic education, a religious liberty claim. They wanted their son to have a religious education, to which the 1925 longstanding Supreme Court decision entitled Jim. In the United States, one has been obligated to attend school, but by right, not exclusively a public school. This is the moment in the Zobrist story when their narrative becomes entangled with the larger legal and jurisprudential history of the Constitution. Under the 1975 law as written, it was not clear what, if any, legal obligation public school districts, which had the responsibility for dispensing funds under the 1975 law, had to use the monies which they were provided for disabled students pursuing a private school education. And that issue was burdened by a question of greater constitutional significance if the private school was religious in affiliation, as was the high school Jim and his parents chose, South Point Catholic High School. Jim's speech therapy could take place on the grounds of a public high school. It would be an extracurricular obligation of the public school district, easily accomplished periodically outside his Catholic high school. But a sign language interpreter could not assist him anywhere but in the classroom daily and throughout the school day. In effect, the Zobrists were asking for the sign language interpreter, who would be implicitly a public employee, to be paid by public funds for work in a religious institution. A situation which numerous previous Supreme Court decisions had ruled against. Whatever the circumstance, public monies were not to be used to pay teachers in religiously affiliated schools. And there could be no doubt of the extent to which an interpreter would be called upon to interpret religious messages at South Point. For the Carmelite religious clergy that controlled South Point proudly proclaimed the intention to infuse the curriculum, wherever relevant, with introductions to Catholic teaching. This situation clearly seemed on the face of it to be an establishment of religion. And while the Zobrist religious liberty claim, the right of their son to have a religious education, lurked in the background throughout the evolution of the lawsuit and always heavily in their minds down to the Supreme Court's decision, it was the establishment issue that proved the ground on which the disposition of their claims was to be adjudicated. So I'll now turn the presentation over to Bruce.
about that? Okay, can everybody hear me now? Yes, okay. Well, we've heard quite a bit about the Establishment Clause and also the Free Exercise Clause. I want to take a look at what the Supreme Court has done in the area of one of the four types of cases it typically is handled regarding establishment, and that is monetary aid to religious education. I can get this to go. Okay, the Supreme Court has, over the last century, really handled cases in three different ways. The first wave or predominant wave was the accommodationist wave, where the Supreme Court would allow for certain kinds of religious activities with state funding, state approval. The second, strict separationist, meaning that the court would not permit any crossing of that line between church and state. And the area that I'm going to probably spend the most time on, equal treatment. Some people call that accommodationist, but I'm going to consider it a third way in which the court has responded to these challenges. The accommodationists believe that government can assist, support, fund religious activities as long as they don't prefer those activities over non-religious goings on. The separationists, like Thomas Jefferson, for instance, believe there's a wall of separation that forbids any kind of favoritism, encouragement, support for religious activity whatsoever. I'm going to take a look at some of these cases. We don't have time for all of them, obviously, but you'll notice the one that we're considering is the Zobrest case falls under the equal treatment division. One of the most important cases came early on, the case of Cochran versus Board of Education. In that case, the Chief Justice wrote the opinion which said that Louisiana could give or loan secular textbooks to children in Catholic schools, parochial schools or sectarian schools, those are synonyms. Although parochial has often been regarded as kind of a pejorative, but I'm going to use those interchangeably. And the Supreme Court argued in Cochran that the Louisiana government was entitled to turn these books over, loan them to students in Catholic schools primarily, because the issue was what was called the child benefit theory. And the church wasn't benefiting, religion wasn't benefiting, it was the students. And that kind of argument would be used in a number of subsequent cases. Incidentally, the Cochran case did not use the First Amendment, did not refer to the Establishment Clause. It referred to general thinking on liberty, fairness, applying common law, but it's out of that thinking that other accommodationist rulings would take place. One of the more seminal cases in the area, this area, came in 1947. David's alluded to it without mentioning its name. And that's the case of Everson versus Board of Education. And we remember this case especially because Hugo Black embraced the metaphor of Thomas Jefferson. The Establishment Clause means to erect a wall of separation between church and state. And he enumerates what that means. Hugo Black enumerates what that is, as you can see on the right-hand side of the screen. But the other reason to remember it is that the Supreme Court, despite this embrace of Jefferson's metaphor, controversial, always controversial metaphor, that the Supreme Court said that parents who send their children to parochial schools can get their transportation costs reimbursed by the government. And so that was an accommodation. A third case in this area, Board of Education versus Allen, involved in New York State. case, and the question was, could New York loan secular textbooks to students in parochial schools? And the court said yes, because, and this kind of thinking would be important down the line, religious schools have secular purposes as well as religious purposes. Second, the primary purpose of the law was to further education and not religion. And third, the financial benefit is to the parents and the children, not to the schools. So in that scenario, it was perfectly legal to provide those secular textbooks to a religious school. In 1971, the Chief Justice at that time, Warren Burger, was frankly kind of tired of the wave of court cases involving establishment that were coming to the Supreme Court. And he said, we are spending too much time on this. We have to figure out a formula to dispose of them more quickly. And what he and the majority of the court decided was there will be a threefold test involving a particular law that's being challenged. In order to be legal, the law has to have a secular purpose. It must be neutral regarding religion, and there must not be too much interaction. Entanglement was the court's word, between government and religion. And all three of those criteria have to be met for it to be considered legal. There were a number of cases that came down the pike where the Lemon case would be used. Meek versus Pittenger involved Pennsylvania, and although it did uphold Allen's ruling that you could loan textbooks to students in Catholics or religious schools, it listed a number of things that could not be done. The state cannot provide films, maps, charts. It cannot help students who are exceptional or remedial with counseling, hearing therapy, psychological services. Those were considered establishment. The high water mark in this regard was Aguilar versus Felton. And here, the court ruled that remedial instruction in religious schools through paying for supplies, teachers, counselors, violated the Lemon's second prong and was unconstitutional. This case would be kind of a lightning rod, and the court would come back to it to redecide it. Justice Rehnquist, who became Chief Justice, was upset, frustrated, puzzled by these decisions that the court was handing down regarding establishment. He called them, quote, unworkable or unprincipled. He thought it was a mess. He said, how is it possible that you can allow a school bus for children? My daughter benefited by that. She went to a Catholic school on a public school bus, but you can't fund a field trip to help the students learn something. How is it possible the state may pay for diagnostic services conducted in the parochial school, but therapeutic services must be given in a different building? Speech and hearing services conducted by the state inside a sectarian school are forbidden, but state may conduct speech and hearing diagnostic testing inside a sectarian school. So he vowed to straighten this out. And he had another opportunity. One opportunity came in the Mueller case where he convinced the majority of the court that tax deductions for parents who sent their children to Catholic schools, religious schools, was permissible under the law because it was a private choice that the parents sent their children to a religious school. In the case of Zobrest, the school district, Catalina Foothills, asked for a ruling from the county attorney and from the state attorney general in Arizona. Is it permissible for Jim Zobrist to have an interpreter? And they said, no, this is going to be excessive entanglement. the third prong of the Lemon test, no go. At that, because it's clear that Salpointe was religious. They had mass every day. They required Catholic theology, Jesus and the Gospels, Christian morality. There's just no question that it was suffused by religion. So Catalina Foothills does not have to supply and pay for an interpreter in Salpointe Catholic High School. At that point, Sandy Zobrest and family sued the Catalina Foothills, insisting that their religious freedom, free exercise, entitled them to have that interpreter, which they had in junior high and in sixth grade in public schools. They said, our religious freedom, we want to choose a religious school for our son. So the case would wind itself up the ladder from district courts to courts of appeal and to the Supreme Court, where it would ultimately be adjudicated. The lawyer I want to mention in the brief time that I have is William Bentley Ball, who it's just one of those strokes of luck, you might say, that William Bentley Ball, the leading Catholic attorney on church-state matters, establishment matters in the country, got this case. It happened that his daughter was Jim Zobrest's first teacher. And one thing led to another, and he got the case. Now, although his daughter dealt with disability, although he was sympathetic to people who had disabilities, the case for him really presented an opportunity to try to reverse the secularism in American society, stop what he regarded as the kingdom of man, where abortion is on demand, divorce is freely offered, euthanasia, etc. And what he wants, I think, more than he wanted disability rights, has to do with Catholic schools not being permitted their fair share of taxes. And so the attractive quality of Jim Zobrest, a handsome young man, tall, well-behaved, I think Jim Zobrest presented more of an opportunity to William Bentley Ball to try to get more funding, state funding, to support the Catholic schools. Ultimately, he hopes to eliminate the Lemon test, which he regarded as a great evil in jurisprudence. The case started at the district level, and Judge Bilby had little sympathy for this because he said, this request by the Zobrest, an interpreter will act as a conduit to spread religious messages, and we cannot permit that. So the case was appealed to the Ninth Circuit Court of Appeals, the most liberal court, and the liberal wing, Betty Binns Fletcher and Stephen Reinhardt, warned that the Zobrest request would constitute a symbolic union of government and religion, and so is therefore illegal. The dissent pointed out some things that would be picked up by the US Supreme Court. One is his contention that sign interpreters are nothing more than a visual hearing aid. They translate, they don't teach, and they have a code of professional ethics which prevent them from proselytizing or assisting a religious school in its religious message. So the case, one of the 3 to 5% that David mentioned, made it to the Supreme Court, and there William Bentley Ball made a constitutional argument, both state and federal, and somewhat mischaracterized what the federal law was in the case. He also argued that sign interpretation is nothing more than a machine, which is not literally true, but that's what his argument was. The school board attorney, John Richardson, was about half of Ball's age and much less experienced. This is his first Supreme Court case. Made, as he realized, a strategic error, and that was that he should have argued the federal statute only required the school district to pay for an interpreter in a public school. But it was too late to make that argument on the statutory basis. The case was written by William Rehnquist. He did not want anyone else but himself to write it, as was his prerogative, because he regarded it as a chance to redirect the court to away from a separationist train of thought. Interestingly, he did not rely on the Lemon test. So in that sense, Ball's mission, and he did not argue for the Ball or the Lemon test to be struck down, interestingly enough. But Rehnquist let this opportunity go by, and he said that sign language interpreters, availability of them is a neutral benefit to any child, whether they're going to a public school or to a religious school. And the parents decide whether their child goes to a private or religious school. So there's no financial incentive to a parent or to a religious school to do that. And he argued that sign language interpreters are not teachers. They are like a machine. So this was an important case because it strengthened the way the court was increasingly going, equal treatment under the law for those children going to religious schools. The case was decided narrowly. In fact, the reason it was decided the way it was an originalist. Clarence Thomas replaced Thurgood Marshall before the case was finally decided. Justice Blackmun criticized the decision because he said the court should have remanded the case back to the Ninth Circuit for reconsideration on the issue of statutory law. There was no need to take a look at the constitutional question. And this idea had been formulated by Justice Brandeis, in the New Deal period, but of course the Supreme Court did not agree with Justice Blackmun. Since the decision of the Zobrest case, there has been some strengthening, some continuity, maybe that's a better word, with a series of decisions. One of the most important was Augustini versus Felton, which the Supreme Court revisited the ban on public school teachers and materials, instructional materials, that had been decided 12 years earlier. And the Supreme Court said, in effect, we were wrong. There's no constitutional bar to remedial instruction to children in religious schools. But that wasn't the only such case. There were other cases too. So I'm about out of time, I'm sure, probably a little over time. In any event, the Zobrest case made these critical points that would be picked up by subsequent cases. First, the state may assist disadvantaged or disabled children in religious schools without falling victim to religious excessive entanglement, one of the prongs of the Lemon test. And second, a public employee, a paid employee by taxpayer money, can work in a religious institution, including a sign interpreter for the deaf. And with that, I'll close my remarks.